case. You're calling Crumbley 216611. And Mr. Kozak, your appearance, or actually Mr. Keys first, your appearance.
Thank you, Judge. Mark Keys on behalf of the people.
Mr.
Once again, Your
Kozak.
Honor, Scott Kozak on behalf of Mr. Crumbley.
Ms. Hatton.
Sorry. Yes, Your Honor, Nadine Hatton. I was formally appointed to Mr. Ethan Crumbley as his juvenile attorney.
Thank you. And Mr. Crumbley, could you state your full name for us, please?
Ethan Robert Crumbley.
Thank you. Mr. Crumbley, at any time you do not hear or understand myself or any of the parties to the proceeding, will you please let the court know?
Yes.
Mr. Kozak, have you had ample time to talk to your client as well as with Ms. Hatton, along with Mr. Crumbley's parents, to proceed with an arraignment?
Yes, Your Honor, and I appreciate Ms. Hatton's presence as well as Mr. Crumbley's parents. I appreciate the court's time in allowing us to get acquainted. Mr. Crumbley was present for the swear-to. He does, for purposes of arraignment, if the court wants me to proceed, I can at this point in time.
Yes, okay. So then I'm going to, Mr. Crumbley, I'm going to advise you of your rights and the charges against you. Again, if at any time you do not hear or understand anything, will you please let the court know?
Yes.
You do have a right to remain silent. Anything you say can and will be used against you in a court of law. Do you understand that right, sir?
Yes, I do.
All right. Count one does indicate that you did that on or about November 30th, 2021, Ethan Robert Crumbley did knowingly, willfully, deliberately, and with premeditation commit murder first degree, a felony that the defendant knew or had reason to know was dangerous to human life while intending to intimidate or coerce the civilian population, to wit, the Oxford High School community, and cause the death of Madison Baldwin, Tate Meyer, Hannah St. Juliana, and Justin Schilling, contrary to MCL 750.543F. This is a felony punishable by life without parole or a minimum of 25 to 40 years and a maximum sentence of at least 60 years with reimbursements for government expenses incurred for this violation. This is otherwise known as terrorism causing death. Count two indicates that on that same date and time, November 30th, 2021, Ethan Robert Crumbley did deliberately with the intent to kill and with premeditation, kill and murder one Madison Baldwin, contrary to MCL 750.316. This is a felony that is punishable by life without parole or a minimum sentence of 25 to 40 years and a maximum sentence of at least 60 years. This is otherwise known as homicide or murder in the first degree, premeditated, being a juvenile defendant. Count three alleges that on November 30th, 2021, Ethan Robert Crumbley did deliberately with the intent to kill and with premeditation, kill and murder one Tate Meyer, contrary to MCL 750.316. This is a felony punishable by life without parole or a minimum sentence of 25 to 40 years and a maximum sentence of at least 60 years, also known as homicide, murder first degree, premeditated by a juvenile defendant. Count four alleges that on November 30th, 2021, and again, all of these, I'm sorry, are in the township of Oxford. I did indicate that, and I will continue to indicate that Ethan Robert Crumbley did deliberately with the intent to kill and with premeditation, kill and murder one Hannah St. Juliana, contrary to MCL 750.316, felony, life without parole, or a minimum sentence of 25 to 40 years, and a maximum sentence of at least 60 years. And this is in violation of MCL 750 again, 0.316. This is homicide, murder first degree, premeditated by a juvenile defendant. Count five alleges that on November 30th, Ethan Robert Crumbley did in the township of Oxford deliberately with the intent to kill with premeditation, kill and murder Justin Schilling, contrary to MCL 750.316, a felony life without parole or a minimum sentence of 25 to 40 years and a maximum sentence of at least 60 years. This is called homicide, murder first degree, premeditated by a juvenile defendant. Count 6 alleges that on November 30th, 2021, Ethan Robert Crumbley did in Oxford Township make an assault on Phoebe Author with intent to commit the crime of murder contrary to MCL 750.83. This is a felony punishable by up to life or any number of years, DNA to be taken upon arrest. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. This is also known as assault with intent to murder. Count 7 indicates that on November 30th, 2021, Ethan Robert Crumbley, while in the township of Oxford, did make an assault upon John Asciutto with intent to commit the crime of murder contrary to MCL 750.83. This is a felony punishable by life or any number of years, DNA to be taken upon arrest. This is also known as assault with intent to commit murder. Count 8 indicates that on November 30th, 2021, Ethan Robert Crumbley did in Oxford Township make an assault upon Molly Darnell with the intent to commit the crime of murder contrary to MCL 750.83. This is a felony punishable by life for any number of years and DNA to be taken upon arrest, also known as assault with intent to murder. Count 9 alleges that on November 30th, 2021, Ethan Robert Crumbley, while in the township of Oxford, did make an assault upon Riley Franz with intent to commit the crime of murder contrary to MCL 750.83. This is a felony punishable by up to life or any number of years, DNA to be taken upon arrest. This is called assault with intent to murder. Count 10 alleges that on November 30th, 2021, Ethan Robert Crumbley, while in Oxford Township, did make an assault upon Elijah Mueller with intent to commit the crime of murder, contrary to MCL 750.83, a felony punishable by life for any number of years, DNA to be taken upon arrest. Also, again, assault with intent to murder. Count 11 alleges that on November 30th, 2021, Ethan Robert Crumbley, while in Oxford Township, did make an assault upon Kylie Assange with the intent to commit the crime of murder, contrary to MCL 750.83. This is a felony punishable by life for any number of years, DNA to be taken upon arrest. Count 12 indicates that on November 30th, 2021, Ethan Robert Crumbley, while in Oxford Township, did make an assault upon Aiden Watson with intent to commit the crime of murder, contrary to MCL 750.83, a felony punishable by life for any number of years, and DNA to be taken upon arrest. This is also called assault with intent to murder. There are now 12 counts of possession of a firearm in the commission of a felony. Counts 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, and 24. They do allege that on November 30th, 2021, in Oxford Township, Ethan Robert Crumbley did carry or have in possession a firearm, to wit, a pistol, at the time he committed or attempted to commit a felony, to wit, terrorism causing death. Also, murder in the first degree for count 14, murder in the first degree for count 15, murder in the first degree for count 16, murder in the first degree for count 17, assault with intent to commit murder for count 18, assault with intent to commit murder for count 19, assault with intent to commit murder for count 20, assault with intent to commit murder for count 21, assault with intent to commit murder for count 22, assault with intent to commit murder count 23, and assault with intent to commit murder count 24. This is contrary to the laws in the state, specifically MCL 750.227B. This is a felony punishable by up to 2 years consecutively consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony of conviction. This is called possession of a firearm in the commission of a felony. Sir, do you understand all the charges against you?
Yes, I do.
Again, you have a right to remain silent. Anything you say can and will be used against you in a court of law. Do you understand your right to remain silent?
Yes.
You also have, of course, your right to an attorney, and Mr. Kozak and Ms. Hatton have been with you, and that right will continue throughout all legal proceedings. And as it relates to anything further, we do need to set a bond. As it relates to bond, I will first let the, actually, we do have pretrial services here to make a recommendation as to bond, and then we will let each attorney speak as it relates to that. So if the individual from pretrial services can come forward, state your full name and spell it for a court recorder.
Your Honor, I'm sorry, Judge, just before we do that, I just want to make sure it's clear that my client is standing mute. We're asking the court to enter a not guilty plea.
Oh, I'm sorry. Yes, I will enter a plea of not guilty on his behalf, and we will set this for bond. Thank you, Mr. Kozak.
Darla Finley, Pretrial Services, DARLAFINLEY. The defendant was unable to be interviewed due to his location at the Children's Village, therefore that we have limited information. We do know that he's 15 years old, resident of Oxford. He's a sophomore at Oxford High School. He has no prior juvenile record, no noted police contacts in Clemens. Given the serious nature of the matter, there's no conditions or combinations of conditions which will assure the defendant's appearance in court or safety to the community at large. Therefore, we recommend that bond be denied.
Thank you from pretrial services. Mr. Keast, anything you'd like to state?
I would, Judge, thank you. Because the defendant is a juvenile charged as an adult, this court must look at Michigan Court Rule 6.909, subparagraph 2. That court rule states that regarding detention without bail, if the proof is evident or if the presumption is great that the juvenile committed the offense, the magistrate or the court may deny bail, subparagraph A, to a juvenile charged with first-degree murder. Judge, in this case, I am asking this court to deny bail as pretrial supervision has indicated. As a offer of proof, I think it's appropriate for this court to have a brief chronology of what happened on November the 30th, 2021. As you heard during the swear-to, Judge, Oxford High School is equipped with surveillance video. We've had the opportunity to review that surveillance video just this morning. And what's depicted on that video, honestly, Judge, I don't have the words to describe how horrific that happened on November the 30th. It depicted just before 12:51 p.m., this defendant entering a bathroom with a backpack. A minute or two later, he exited the same bathroom without the backpack, but with a gun in hand. At that point, he methodically and deliberately walked down the hallway, aiming the firearm at students and firing. Right outside the bathroom, he began firing, Judge. After children started running away from the defendant, he continued down the hallway, again at a deliberate and methodical pace, pointing and aiming inside classrooms and at students who hadn't had the opportunity to escape. This continued on for approximately 5 minutes. The defendant went to another bathroom. As deputies arrived, he set the firearm down and he surrendered. Judge, a preliminary review of the defendant's social media accounts, his cell phone, as well as other document evidence recovered on scene show that this defendant planned this shooting. He deliberately brought the handgun that day with the intent to murder as many students as he could. Judge, I believe no bond is appropriate. And again, like I stated, at the appropriate time, I'd like to make a motion to transfer this defendant from Children's Village to the Oakland County Jail.
Thank you. Mr. Kozak?
Your Honor, understanding the extreme nature of this case and understanding the circumstances at hand, and having spoken to Mr. Crumbley as well as his parents, I'm going to leave the setting of the bond and the discretion of the court.
Thank you. Anything further from Ms. Hatton?
Nothing further, Your Honor. I leave in the discretion of the court.
Thank you. And I'm assuming you don't want your client to speak.
That's correct, Your Honor, on both Mr. Kozak and my behalf.
Thank you. I do believe, based upon all the information that's been provided to date, that a no bond, a denial of bond is appropriate pursuant to court rule, and I will order no bond on this case. Of course, your client does have a right to a preliminary exam within the statutory 21 day time period, as well as a probable cause conference. I don't know if the court should have set something, or have we set something? Do we know? Oh, it's on the front of the file? Okay. All right. A probable cause conference will be set on December 13th at 1:15 in front of myself. And then an exam the following week on December 20th at 1:15, again in front of myself. Anything further from the people or the defense?
Thank you, Judge. I do have a motion for the court. The defendant's currently housed in Children's Village, if I may.
Yes.
Thank you, Judge. Under the same court rule, MCR 6.909, subparagraph B regarding place of confinement. Subparagraph 2, on motion of a prosecuting attorney or a superintendent of a juvenile facility in which the juvenile is detained, the magistrate or court may order the juvenile confined in a jail or similar facility designed and used to incarcerate adult prisoners upon a showing that the juvenile's habits or conduct are considered a menace to other juveniles. Judge, in this case, I can't think of a more appropriate set of circumstances for a transfer from Oakland County Children's Village to the Oakland County Jail. Now, this court must also look at the statute, and that's MCL 764.27A. I spoke with Lieutenant Tim Willis, who is the officer in charge, into the square to this afternoon. He has confirmed that the Oakland County Jail can house this defendant in a location out of sight and sound from adults, and that's the standard in the statute, Judge. The Oakland County Jail is better equipped to handle this situation. They have done so in the past. They have done so in conformance with the statute. It is a more secure location. And I would ask that this court find that this defendant's conduct is a menace to juveniles by evidence of the simple fact that he targeted juveniles in this offense. Count 1 is a charge of terrorism via murder, Judge, and the evidence that will come out of the preliminary examination and the subsequent trial will show that this was a planned event. It was methodical in its operation, and it was done so to terrorize, intimidate others in the community, Judge. I do believe the Oakland County Jail is the appropriate location to house this defendant. Thank you.
Thank you. As it relates to that issue, Mr. Kozak and Ms. Hatton.
Thank you, Your Honor. All due respect to Mr. Keast, Your Honor. I want to remind the court, and I know the court doesn't need reminding, that these are allegations. He has not been found guilty of these issues or these charges as of yet. And I'm asking the court to, I'm objecting to the transfer at this point in time. I think the Children's Village is more than capable of monitoring him and maintaining the safety of the other residents of that facility. And I think at this point, Judge, if the court's going to consider this motion, I would ask the court to perhaps hold the ruling in abeyance until after the preliminary examination, at which point the court will have had a chance to have taken sworn and heard sworn testimony regarding these incidents.
Regarding the
Regarding
issue
the
itself, or
incident,
regarding the fact that he shouldn't be moved?
Regarding the incidents itself, Your Honor, and because I believe that's what the prosecution is using as a reason for the transfer in and of itself. That's evidence of the need to transfer.
Thank you. Ms. Hatton?
Your Honor, just very briefly, this court has already found that the proof is evident under 6.909. And I know this is a preliminary showing. Obviously, defense has not had the opportunity to review discovery, neither has this court. However, it is alleged in these 24 counts that this defendant didn't commit first-degree murder upon anybody, but he targeted other juveniles. And I believe that 6.909 subparagraph B is written specifically for a situation such as this. The Oakland County Jail is the appropriate location for this individual, Judge. It is, like I said, well equipped for this. They have the ability to keep this defendant separate from both sight and sound of other adults. This is appropriate in these circumstances, Judge.
Ms. Hatton, anything further?
Your Honor, I concur in Mr. Kozak's argument. I will advise the court that as Mr. Ethan Crumbley's juvenile attorney, I did have an opportunity to speak again with Mr. Ethan Crumbley at the juvenile facility, Children's Village, as well as the individuals who are supervising Mr. Crumbley, Ethan Crumbley at Children's Village. It's been reported to me, Your Honor, as an officer of the court, that Ethan has been cooperative. He is on suicide prevention there at Children's Village. He's not in general population. He's secluded and he's receiving one-on-one supervision. I would ask the court, based on that information, and that he is cloaked in the veil of innocence unless proven guilty, that he remain at Children's Village until after the preliminary examination. Given that Children's Village is suitable and able to maintain the safety of the other children at Children's Village, I believe it is appropriate at this time that Ethan remain at his current placement with the current conditions and supervisions in place until the preliminary exam, which is in a matter of days, December 20th, 2021, as this court has set.
Thank you. I'm going to ask to hear from Lieutenant Willis regarding safety issues and what is considered. If you want to come up to the podium, Lieutenant, and state your full name for us, please.
Lieutenant Tim Willis.
And Lieutenant Willis, I had heard from Mr. Keese that you thought it was appropriate for him to be moved to the adult facility. Is that correct?
Yes, Your Honor.
Okay, could you explain to me why you feel that way?
Well,
I mean, besides the obvious of what is alleged to occur.
right. So obviously, I agree with Mr. Keese about the incidents that I've witnessed for via the video and all that stuff. But also the sheriff's office in the past has housed several juveniles. I've actually worked in that jail and know for a fact how I just have all the confidence in the world in my team, the sheriff deputies at the jail, to secure him and keep him completely sequestered.
So how does that work? Explain what would happen to him and how he would, what his placement would be.
Yes, Your Honor. We have several jail cells in and around, but typically we have where he would go, where he would be placed is a clinic area, and it's completely secluded off from the rest of it's the only thing, there's a glass front door, but everything else is bricked in. So it's completely private, completely back and away, and a deputy monitors him.
So we would have no contact whatsoever with any adult inmates, is that correct?
That is correct, Your Honor.
Okay, and he would be in that facility by himself?
Correct, and there would be no, again, the only adults he would hear would be the deputies working there, but
All right.
no inmates.
Thank
Not
you.
see them or hear them.
Thank you.
Yes, Your Honor.
Under the circumstances and based upon the nature of this offense, still, of course, understanding that the defendant has a right to be presumed innocent until proven guilty beyond a reasonable doubt, I'm going to certainly err on the side of caution. I think it is within the court rules to do so. And I would agree with Mr. Keese. This is the perfect example of a case that should be done to protect other juveniles. So I will have him move to that facility, as it has been indicated that he will be in isolation and will not be in contact with any other adult inmates, but only that of sheriff's deputies. Anything further?
Not from the people, Judge. Thank you.
Your Honor, the only other matter would be making sure that he has counsel at the date of the probable cause conference. I'm not sure if the court has paperwork already prepared on his behalf, but he will need court-appointed counsel at that point in time.
So I'm not sure who that is obviously is done by circuit court. Do we know what's going on in that regard?
He will just need to fill out the court-appointed attorney request, Judge, and they will get.
Okay, so, all right, Mr. Crumbley, we want to make sure that you have counsel at each and every future court date. So we're going to make sure you have that paperwork today to fill out so that you can make, so that you will have an attorney present at your probable cause conference, your preliminary exam, and all future proceedings. Do you have any questions about filling out that court-appointed attorney form?
No, Your Honor.
Okay, thank you. Thank you, Mr. Kosak. Okay, if there's nothing further, we are in recess. Thank you.
Thank you, Judge.